The legal profession. For most of recorded history, the legal profession has existed in some capacity. Individuals familiar with the legal structure of a country have proven fundamental in the functioning of its judicial body. The legal profession continues to grow today as legal issues become more complex and more stages for legal disputes evolve. The earliest known lawyers were Athenian orators, who were advocates for people being tried under the law. Initially, Athenian law dictated that individuals had to plead their own cases. This law was later disposed of when it was recognized that many people were not capable of defending themselves. Since then, legal advocates have been an important part in every legal body. Ancient Rome formalized the legal profession with an official recognition of people learned in the law, known as jurisconsulti. Even though these Roman advocates did not make a living by practicing law, they were recognized by the state, and as such it is arguable that the Romans were the first people to have a legal profession composed of individuals who specialized in the law. With the fall of the Roman Empire and the onset of the Dark Ages, professional lawyers were practically unheard of. The Church, being the sole authority in most legal matters, was responsible for making legal decisions in criminal and civil issues. Although it was not a profession, many people specialized in canon law, the body of thought that directed the Church's legal decisions. With the Enlightenment, the legal role of the Church was marginalized. Legal codes developed in European countries that rejected the traditions of the Church. It was during this time that two separate bodies of law developed. Criminal law evolved as a system of recognized crimes and subsequent punishments that were under the purview of the state. Civil law, on the other hand, provided an arena where individuals could settle disputes with the benefit of a judge in a court of law. As the legal structure became more advanced and complicated, lawyers started to specialize. Criminal lawyers and civil lawyers emerged. Presently, law schools offer very specific specializations, including family law, personal injury law, criminal defense, criminal prosecution, international law, and immigration law, among others. All specializations require a basic understanding of a country's legal structure, but bodies of law are getting larger and more complex. New legal issues are cropping up almost every day as technology advances. The role of lawyers varies in different nations. Lawyers are always responsible for legal research so that they may practice according to the latest developments in their field. They may also be responsible for giving oral arguments, drafting documents, and offering legal advice. In addition, they may carry out the orders of the deceased according to her will and be responsible for protecting intellectual property. Given the complex legal structures and the number of responsibilities, it comes as no surprise that the legal profession requires significant education. The amount of schooling required varies from country to country, and in some countries isn't even uniform. Most countries require that an exam be passed in order to practice law or give legal advice. The judicial structure of a country plays a large role in the way law is practiced in a country. Some countries use an inquisitorial system, where a judge is charged with prosecuting the individual before him. It is up to the lawyer to prove to the judge that the individual is innocent. Alternatively, some countries employ an adversarial system. A judge acts as a mediator between the prosecutor and the defendant, both of whom are lawyers. Depending on a country's judicial structure, the way law is practiced can vary dramatically. Interestingly, the legal profession was abolished in Prussia in 1780 and in France in 1789. In both instances, the country soon learned that lawyers were an important part of the country's legal operation. Besides providing counsel to individuals, lawyers also speed up the legal process by doing research that would normally be up to a single judge. Although the public often criticizes lawyers, they are a central part of an efficient judicial body in any country.